Case 2022-2134 DM Aaron Gentry versus Peter Gentry. Today is Monday, January 27, 2025 at 9:44 a.m.
Court will note the appearance of Ms. McNiff on behalf of the plaintiff, Ms. Thomas on behalf of the defendant. Court will note that this is before the court on the defendant's motion to show cause, which was renoticed from last Tuesday, I should say, in this matter. And Ms. McNiff has filed a response. So Ms. Thomas, if you wish to proceed, I don't need you to reiterate your motion. I'm well familiar with that. Maybe respond to Ms. McNiff's answer.
Oh, no. Cindy, we cannot hear you.
I'm sorry. I forgot to turn it back on because I turned it off when we were switching clients. Sorry. At this point in time, the plaintiff is claiming and alleging that first and foremost that she has followed the letter of the law, which in the letter of the order and the intent of the order, which we believe is absolutely not true. I have a MLS residential active agent detail report for that house, and it indicates the listing date was 1/18/25. So clearly that's when it was listed. It was prior to, after receiving the listing agreement. It definitely said off market when you pull up the house and look at it. It was listed 12 days after the date that it was ordered. Moreover, the house, this court ordered specifically that it was to be sold forthwith, and when counsel requested additional time to even get it listed, the court said no. So I don't know how that could possibly be then interpreted to that it would be okay to list it, not really have it live listing, just have a listing agreement, but it's not live. And then ask for possession 30 days beyond the closing for one thing, which of course we've been accused of being retaliatory at this point. And then also it was contingent upon the seller finding suitable housing, which was certainly not ordered by this court and does not comply with listed and sold forthwith, which is exactly what the court ordered. We did receive a response from Ms. McNiff yesterday. Again, it's filled with excuses as to why it wasn't timely listed. Irrespective of what a realtor may or may not have suggested, the realtor doesn't trump the court. The court very specifically ordered the house be listed and sold forthwith, and that within 14 days, it was to be listed, and it was not. And the listing agreement was to be given to us within 14 days. We received the agreement, but it wasn't listed, and it wasn't listed until the 18th. Actually,
this is just being redundant now, Ms. Thomas. I'll let Ms. McNiff respond, and then.
Well, you're right. If I can, there's a couple more things that were.
Well, please don't just reiterate everything that's in the pleadings or what you've already said.
Okay. Again, to state that defendant would have claimed that if there wasn't, if she wouldn't have taken all these times, that we would have assumed, and we've undermined it, saying that they were undermining and not trying to get it sold on time, which is speculative at best. But anyway, Mr. Gentry's not receiving proceeds. That's not what this is about. This is just getting the mortgage out of his name. To apply, she's only had 14 days to do it. It's not true. She's had well over 2 years to do it, and it just simply wasn't done. The second paragraph of plaintiff's response is very telling. First, Mr. Gentry and I did discuss the likely price point after having looked at the SEV ×2, the taxable value, his knowledge of the home, and after discussing similar homes in the area with a realtor. And again, this court ordered what it ordered, and forthwith meaning immediately, promptly, without delay, done without excuses for delay. And
okay,
that's.
Hold on, Ms. Thomas. That's added nothing to this thing. I'm going to Ms. McNiff at this point.
Okay.
Go ahead, Ms. McNiff.
Thank you, Your Honor. Your Honor, the order indicates that the listing agreement was to be provided within 14 days. It was provided within 14 days. It does take time to prepare a house for sale. My client wasn't expecting to have to prepare her house for sale. The order doesn't require that the listing go live within 14 days. She went live as soon as she possibly could after making the adjustments that the realtor asked for. It is currently live. As of this morning, there have been 1,786 views on Zillow alone and 195 saves. So this idea that she has it listed too high, again, Ms. Thomas is not a realtor. Her client is not a realtor. Without some sort of expert testimony, I don't think the court can determine whether or not the price range is too high for this particular house. There certainly is interest in it. There have been showings of it. My client is doing everything she can to get this house sold. However, it's reasonable for her to ask for to maintain possession 30 days after closing. In the event that she doesn't have a place to live, she will need at least 30 days to find a place to live. Hopefully she can find a place to live prior to that. But if she gets an offer tomorrow, she's going to need a little bit of time. We're in compliance, Your Honor. This is simply a harassing tactic on the part of Mr. Gentry.
Okay. Well, if she gets an offer tomorrow, she's not going to close tomorrow. There's going to be obviously sufficient time for her to make arrangements. The court did not put any conditions on the listing or sale back when the court ordered it back on January 3rd of 2025. So the court isn't going to allow parties to come in and unilaterally put conditions. So the court is going to order that the property would be sold without conditions. So her condition about finding suitable housing or staying after closing have to be removed in this manner. She'll have to get out of the house at the date of closing like everybody else does when they sell a house. The court will leave the price at the current amount because it does appear that there's been interest in that, and we'll see if there's some offers. If we have to adjust the sale price, then you can bring it back in at that point, and we can adjust it if the parties are not willing to agree. So Ms. Thomas, you can prepare that order reflecting that, and we'll hopefully move along and get the matter sold as quickly as possible.
Your Honor, as long as the plaintiff did not do it pursuant to the order and added conditions that weren't approved by the court, Mr. Gentry had to bring it back. Is there any way he can get attorney fees? It wasn't done the way it was.
I'm going to reserve that at this point.
Okay. Okay, thank
Free
you.
to go. Have a good day.
Thank you.
Now we are doing Gorham.
Okay, one moment to open the record here. The 37th Circuit Court is in session with the Honorable Brian K. Kirkham presiding. Today is Monday, January 27th, 2025 at 8:30 a.m.
Good morning, Ms. Brown.
Good morning, Your Honor. How are you?
I'm doing great. You?
I'm good, thank you.
Good. You can proceed when you're ready.
Okay, before the court this morning is Terrence McClinton. Mr. McClinton has 4 dockets total. Docket 2014-663 DP. That docket currently has a bond set at $500, and this is his 6th warrant. Docket 2017-2465 DS. That docket currently has a bond of $1,645, and this is the 3rd bench warrant. Docket 2014-1534 DP. That docket has a bond currently of $2,082, and this is the 6th bench warrant. And lastly, docket 2022-691 DZ. That bond is currently $1,474, and this is the 3rd bench warrant. Mr. McClinton failed to appear on January 10th of this year for a show cause hearing before Referee Coleman. Friend of the court is asking that we set the next hearing on these 4 dockets on February 5th of 25 at 8 a.m. before Your Honor. Mr. McClinton's last payment on these cases was June of 24, and that was through an income withholding.
Okay, thank you.
You're welcome.
Mr. McClinton, you're before the court, currently charged with civil contempt of court due to your failure to appear at a prior proceeding as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your attendance at the next hearing on February 5th, 2025 at 8:00 a.m. You will get notice of that in writing. Are you able to post a bond in these matters, sir?
For how much the bond is?
I'm just asking if you're able to post a bond.
Yes, I mean, depending on how much the bond, yes.
Okay. Well, court notes that, again, that you haven't paid since back in June. And two of these you have, it's your sixth bench warrant, so I'm taking that into consideration. But, and you have a sizable, when we add it up, you have a sizable arrearage, but I want to give you an opportunity to get out of jail before that hearing. So I'm going to set your bond in each case in the amount of $200. If you're able to post that, you'd be able to be released. Do you have any questions?
So it's $200 for all of them?
Nope, it's $200 per case, so it's $800 total.
Okay,
You're free to go. Have a good day.
thank you.
Do you have any bench warrants, Ms. Brown?
No,
Oh.
Mr. Chapman, we can cover those on Wednesday,
Oh, okay. Guess he was slacking off, huh?
as usual.
Okay. You
Okay,
have a good day.
thank you, you too. Bye,
All right,
Jesus.
take care, Sonia. All right. Josh, we're gonna have to pause for a second.